Welcome back to this third part of succession law, and in particular, intestate succession. We are reviewing intestacy, and we are not at the point where we need to consider issues such as the statutory entitlement, the statutory legacy. Well, you've heard me keep saying about the statutory legacy and the fact that the spouse takes the statutory legacy and then whatever else he or she takes. Well, let's examine that for a moment. The statutory legacy, of course, what has always been the statutes, the position set out in statute as to what the spouse will get. Now, in June 2005, the Department for Constitutional Affairs published a consultation paper reviewing the amount of the statutory legacy, and it suggested that the amount should be increased to £350,000 where the deceased left issue, and to £650,000 where he left no issue. Now, why is there such a focus on the statutory legacy? The point is that, as we've looked at in the previous segment, one of the things that is considered is what is the point of intestate succession? And the idea, of course, is what it is that the intestate would have liked for his family. He just didn't make a will. Now, in the vast majority of cases, the biggest asset is going to be the matrimonial home. Now, of course, if the statutory legacy is too low, it means that if there are issues, it may very well be not only has this person lost their husband or wife, but they then now will be at risk of losing their home. So, of course, the higher the statutory legacy is, the more likely that the matrimonial home, being most times the only major asset, then at least the surviving spouse can at the very least get the matrimonial home based on the fact that it would be covered when you did a calculation as it relates to the statutory legacy. Now, there is a belief that the increase in the statutory legacy suggested in the consultation paper was an attempt by a different route to implement what was raised in a previous law commission report in 1989 and which was not adopted, and that was that the surviving spouse should take the entire estate. It is a little bit of a delicate subject, because on the one hand, you're seeking to allow the surviving spouse to remain in the home, but on the other, what if the decedent had children who may very well need looking after, except that the parent has now died? Well, the Balancing Act seems to weigh in favor of the surviving spouse. Notwithstanding, the Family Provisions Intestate Succession Order of 2009, which actually came into force in 2009, did increase the statutory legacy, but not to the proportions mentioned. What it did do was to increase it to $250,000 where there is issue, and $450,000 where there is no issue. So clearly, the value of the house, value of the property, most often than not, it is likely that the spouse will take. Now, in respect of personal chattel and its entitlement, Section 46 says that the surviving spouse will take absolutely. Now, what is personal chattel? If I can pause and say this, that the interesting thing about law is that you may raise a word or a phrase, which if you said it to the layman, it would mean something very simple. But this is law, and this is how we make our money. So it has to have a degree of technicality in it. Well, not really, but you get the idea. What is meant by personal chattel? Off the top of your head, you might say, well, it's anything that I own personally. But that is where I would urge you to go to Section 55(1), Roman numeral 10 of the AEA, the Administration of Estates Act 1925, and look at the definition that is stated there, because this is one of the areas that is certainly, arguably, ripe for reform. Now, under Section 55(1)(10), it says personal chattel means carriages, horses, stable furniture and effects, not used for business purposes, motor cars and accessories, not used for business purposes, garden effects, domestic animals, plate, plated articles, linen, china, glass, books, pictures, prints, furniture, jewelry, articles of household or personal use or ornaments, musical and scientific instruments and apparatus, wines, liquors, and consumable stores, but they do not include any chattel used at the date of death of the intestate for business purposes, and it does not include money or securities for money. It's interesting because when it talks about horses and carriages, it does take you back to a particular time, and which arguably suggests that the law does need updating. But there it is. That is the definition we're still working with. So of course, it is going to mean that we are going to have an awful lot of situations where things have to be drawn by analogy. Now, surprise, surprise, the definition has caused tremendous problems because of its specificity. It has specified certain items and excluded others. Now, if I may pause and take you back to, for example, your common law reasoning days, and if you remember when you would have done things like, for example, statutory interpretation, and it says the inclusion of one thing means that other things are excluded. This is one such situation where you're looking at a statute that is so specific that it does create problems. Now, in one case, Ray Whitby, in 1944, the question, of course, to be decided in front of the courts was whether cut diamonds, which were unmounted, fell under jewelry. Court said yes, it did. But that's the kind of legal gymnastics that have to be attempted by the courts in ensuring that there is a fair degree of reasonable interpretation. In Ree Hutchinson, which is a 1955 case, the horses, the court says, were interpreted as including racehorses and horses for domestic purposes. The thing you need to be careful of, though, is that business use chattel as exception, because you will see on some exams that they will raise things about, for example, the person has a particular vehicle or something like that. And the question then is, he said, sometimes he rented it out, sometimes he didn't. There is no English case on the point, but there is a Canadian case, Ree McCullough's estate. It's a 1981 case in which the intestate had a yacht, which he used for his and his wife's use. Now, you know that anybody who's going to have a yacht is not necessarily going to be a poor person. In fact, this chap's wife was actually an actress at the time, and he left all his personal chattel to the wife. Now, the court said that she was not entitled to the yacht, as the dominant use of the yacht was commercial, because he used to hire it out for pleasure cruises. But even though he did use to hire it out for pleasure cruises, he did also use it for personal use. The point, though, is the court considered that it did not fall within that definition. And it is a useful exercise, and it is a useful case, because if you get an exam, that is something that you will have to discuss. I keep mentioning issue and issue and issue. Well, who are issue? What do we mean by issue? Well, it is clearly, of course, the children. And we want to start off with illegitimate children. Well, illegitimate children are children born out of wedlock. Prior to 1969, certainly their rights were extremely limited. However, since the Family Law Reform Act of 1969 and 1985, legitimated children, so where the parents got married, as well as illegitimate children, are pretty much on a statutory footing. Legitimated children, again, have similar rights as legitimate children. So legitimated children are when they were born out of wedlock, but the parents then got married. It is of very little significance today, but it does allow you to see what is meant by issue. Because when you look at legitimate children and illegitimate children, they can take. Adopted children can take. They are treated as legitimate children. But contrast stepchildren. So if, for example, you married to the child's parent, but then they are not adopted or otherwise, then stepchildren have no right to take an intestacy, and that goes vice versa for the step-parent as well as the stepchildren. That is not to say as well, again, family law may pick up the slack where succession law falls short. Because again, if it was that the step-parent was looking after them, they may very well be able to get something in that manner. The Human Fertilization and Embryology Act of 1990 also raises interesting issues, because here it's where, for example, you have somebody who has had IVF. Now, if the woman carries a child as a result of having the embryo placed in her, the law says that there is a presumption that the child is of the husband's unless it can be shown that he did not consent. Now, I will not touch on certain family law issues here, but the point, of course, is that when you look at the children in respect of IVF, there's a whole rush of legislation that deal with them. But the point is, the presumption is that if the child is born and at the time the mother is married to the father, it is presumed the husband is the father of that child. Here's an interesting scenario as well. What about children born posthumously? So what if the father has died, but the child is born and also conceived, just follow me with this, and is also conceived after the husband has passed away? Well, there have been advances in medicine, and that's why I say follow me with being conceived. Because what if the husband and the wife have had, for example, a frozen embryo situation? So one biological parent dies and they have the ova and the sperm, and the other parent says they want the child to be carried. Can that child then fall under the intestate succession in respect of the deceased? Well, again, no English case on the point, but there is useful guidance in an Australian case called In Estate of K. Now, after the husband's death, the wife had the embryo implanted into her, the result of IVF of the wife's ova with the husband's sperm. Now, the court the court explained it in this way. They said the embryos were not issue as they were not in existence as at H's death. But they said it became the children of the decedent if the birth resulted, and therefore they could take an intestacy. I think it has to be a common sense decision, because otherwise it would be biologically it is this dead man's child, but then the law is saying that they can't take an intestacy. But what of the English law? Well, if you go back to the provisions in Section 47 of the Administration of Estate Act, it does say very clearly that the child must be living at the death of the intestate. So based on a literal interpretation, it might not follow that English law would go down a similar route as was taken in the estate of K. Now, if we consider how children take, it's on the basis of statutory trust. Now, when issuers take an intestacy, they take on what is called a statutory trust. And Section 47(1)(1) say that the children must be 18 or older, or if they're younger than 18, they were married at that time. So if they're under the age and married, then they can take a vested interest. Over 18 or under 18 and married can get a vested interest. Their entitlement then is what is called per stirpes, which means through the stems. So the estate is distributed through the stems or through the branches of the family, each of who is entitled to an equal share. So for example, when you look at children, the number of branches is determined by the number of children. So if you have 2 children and there is no next of kin, there are 2 branches and it is shared equally. But if A, for example, predeceased the estate, so let's assume A is one of the children of the intestate and A predeceased the intestate and A had children, then his share being vested would then pass to his children per stirpes. When you look at the rule, that is pretty much how it works, that if A and B are, say, Z's children rather, and A and B are over 18, it is vested. But if A dies before Z, then it would go to their children. Now, no surviving spouse or issue present, then the intestate distribution will be in the following order, says section 46. Parents will get brothers and sisters of what is called the whole blood. So this is not just a Harry Potter made up phenomenon. If you have no child or no spouse, your parents will get first. If your parents are deceased, your brothers and sisters of the whole blood, meaning that both parents, you have both parents in common with the intestate. The next line of succession is brothers and sisters of the half blood, one parent in common with the intestate. Then the grandparents, then uncles and aunts of the whole blood, then uncles and aunts of the half blood. If you have no surviving relatives, those are the specific relatives I mentioned before in earlier segments. If you don't have any of those in that order, it passes to the crown, bona vacantia. We're going to take a short break, and after the break, what we will consider is what have been the recent reforms and where is the law looking to go as it relates to succession and intestacy.